This is case number 23 CR 166, State of Ohio versus Audrey v. Edwards. Appearing on behalf of the state is Assistant Prosecuting Attorney King. Appearing on behalf of the defendant is Attorney Jacob Wagner. Are you Aubrey v. Edwards?
Yes, sir.
All right, Ms. Edwards is charged with aggravated possession of methamphetamine, a fifth-degree felony. Been a motion filed for intervention in lieu of conviction. Court ordered a report from the probation department, which I have received. It also indicates that Ms. Edwards is now well, it says that from the Recovery Council, the report indicates that Ms. Edwards feels that she no longer needs the SUD program. Are you still going to classes?
Yes, sir.
When did you last time go?
Yesterday, actually.
Okay.
No, I'm in transitional.
Pardon me?
Okay. I'm sorry, I didn't know she moved from residential to transitional, Your Honor.
Yes.
I was just asking her what state she was in.
I'm at Women's Waverly Transitional House.
I'm sorry?
I'm at Women's Waverly Transitional House on 23.
Is that for the Recovery Council?
Yes, sir.
Oh, yeah, I see it is now, yeah.
I've been there almost 3 months now.
Okay. All right. Well, Ms. Edwards, just explain to you what the intervention program is. Typically, if a person is found guilty of a crime, whether it's by a trial or a plea, then they are sentenced. And that can be, in this case, prison time between 6 and 12 months. It can be a fine of $2,500. It can be a license suspension 6 months, 5 years. It could be community control or probation for a period of 5 years. When that happens, that means that person has been convicted. Now, there's a special provision under the law, which is what you requested and the states agreed to, and that is that if you plead guilty and remain in and compliant with a treatment program for substance use disorder and or mental health as applicable, if you complete that program successfully, then after a period of supervision, which could be up to 5 years, I set it at 2 years, and if you comply with the conditions, which are not as strict as if you were convicted, and you comply with your treatment program, and you don't use either alcohol or drugs other than as prescribed for a period of at least 1 year, then upon completion of the program, the charge is dismissed. And so even though you plead guilty, you're not a felon, because until there's a finding of guilt and a sentence, you're not convicted. So even if you plead guilty, if you're in this program and somebody looks at the file and says, well, you pled guilty, so you're a felon, no, because you've not been sentenced. It's still pending. And the advantage to you is if you complete your substance use disorder program and comply with those conditions, then you will have your case dismissed after 2 years, or sometimes earlier if you pay the court cost and they indicate you're no longer in the need of regular ongoing treatment. So that's the advantage to you, and that's what's being offered to you. Now, the thing that concerns me is you're saying that you told them you don't think you need SUD, substance use disorder, but that you have some other medical issues, which is, and quite honestly, other problems are what usually cause people to abuse drugs. And so if you do have other medical issues, I'm not doubting that you do, the stress of that and the trigger of that, coping with that oftentimes causes people to go into abusing drugs. And so you know, I just want to let you know that I'm going to go ahead and allow this to happen if this is what you want to do, but you have to be committed to completing and complying with that program. Now, are you going to stay in the program? Because if you're not, there's no sense in us wasting any time.
Yes, sir. I'm planning on staying and finishing until the end.
All right. Well, the charge against you, well, first of all, I have this agreement here that's been presented to me that says you're going to plead guilty. And on page 3, there's a sentence that reads, I entered this plea voluntarily, and your signature, Audrey Edwards. And you signed this document?
Yes, sir.
Do you remember when you signed it?
It's been at least a month ago.
All right. So you're, have you had any change your mind at all? Is this still what you want to do?
Yes, sir.
And you're doing this voluntarily?
Yes, sir.
All right. So the charge is aggravated possession of methamphetamine under 2925.11 of the Higher Revised Code, 5th degree felony, which carries a possible prison term between 6 and 12 months, a fine of up to $2,500, and a possible license suspension of 6 months to 5 years. You understand that?
Yes, sir.
All right. And I believe, according to the report, although you've had quite a few misdemeanor, now let me make sure I got the right, there's a number of misdemeanor offenses. This, you don't have anything pending against you at the present time, do you?
No, sir.
Okay. You're not on probation, community control for a felony, correct?
Correct. Well, my probation officer right now.
Well, this is pre-trial, but I mean for a conviction.
Oh,
Yeah.
She has
Never
been
be
issued.
convicted of a
Yeah.
felony.
no.
All right. Because I see you have been in court quite a bit the last year. And I see you did have a diversion program back 15 years ago, almost 16 years ago in Franklin County, but that was for a misdemeanor, domestic violence. Okay. Now, as I indicated, if you are granted this, which is my intention to do, you'll be put into this program for a minimum of 2 years, could be up to 5 years, but I just start out with 2 and see how it goes. And if you comply with those conditions, then once I receive that notification from the probation department that you've complied, the case will be dismissed even though you pled guilty. And then at that time, the court will set the matter for a sealing hearing and will seal the record unless something happens that makes it not appropriate. Now, in the event that you fail to comply with the program, in the opinion of the probation department, they will file a written notice of that with the court, and they'll give you a copy. There will be a hearing. You'll be represented by an attorney at that hearing. If you can't afford to hire one, the court will appoint one for you. And if the outcome of that hearing is that you have failed to comply, then at that time, the court will terminate you from the intervention program, find you guilty, and then you'll be subject to being sentenced. Now, at that time, it could be, as I said, 6 to 12 months incarceration, $2,500 fine, and a license suspension of 6 months to 5 years. Or it could be community control. Community control, then, is probation. That can be for a period of up to 5 years. The conditions for that would be much more strict, and there would be quite a few more of them, because at that time, then, you are a convicted felon. But the same situation applies. You'll be supervised on the conditions set by the court, and if the probation department determines in their mind that you're not compliant, they will file an allegation of that with the court. There will be a copy given to you. You'll be entitled to have an attorney and a hearing on that matter. And at that time, if it's found that you have failed to comply, then you could be sentenced to a term of incarceration of 6 to 12 months, fined $2,500, and have your license suspended for 6 months to 5 years. You understand that?
Yes.
Now, if that happens, then, and you're sentenced to prison, upon completion of the prison term, then at that time, the adult parole authority, as part of the sentence, may decide to put you under post-release control supervision for up to 2 years, meaning you'll be supervised by a parole officer on the term set by the APA. And if they determine that you've not complied, then they can return you to prison to make you serve an additional period of up to half of the prison term that you were required to serve, in this case, for one or more violations. But if you commit a new felony, under post-release control, then in addition to whatever sentence a judge in that new felony case could impose upon you, that judge could also sentence you for committing that violation while under post-release control, in this case, to an additional period of a year, whatever time's left on that period of post-release control, whichever is greater. If that occurs, that must be served consecutively to the sentence of the new case. You understand that?
Yes.
All right, now, the charge in this case alleges that on or about May 21 of 2023 in this county, you did knowingly obtain, possess, or use Schedule II controlled substance, quit methamphetamine. So that's the charge we're talking about. Now, do you understand what it is you've been charged with by the state, what they said you did, when, where, and how they alleged you did it?
Yes.
And you understand the possible penalties for that offense?
Yes.
Now, have you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, and possible defense you might try to raise at trial, and possible outcomes of a trial with your attorney?
Yes.
And are you satisfied with his advice and competence in this matter?
Yes.
Are you under the influence of any types of drugs or alcohol at this time?
No.
Are you taking any prescription drugs that impair your mental acuity, your ability to understand or to relate what you're thinking or understanding?
No, sir.
Okay. Has anyone threatened you to make you plead guilty here today?
No, sir. All
right. Other than being promised to be put into the intervention program, has anyone promised you anything other than that?
No, sir.
All right. Do you hold any license or certification from any state governmental agency that regulates any occupation or profession in Ohio?
No, sir.
Right now, since you're going to plead guilty in this case, in order to be put into the intervention program, you must understand your constitutional rights before I can permit that to happen. First of all, you have a right to have counsel. Mr. Wagner's been appointed to represent you. His appointment wasn't simply to try to work the case out, but to provide any defense to you that is available under the law that you would like him to provide. So if you decide you don't want to do this, that you would rather defend against the case in charge, including a trial, he'll continue to represent you and do that. You understand that?
Yes, sir.
Now, under the Constitution, you have the right to have a jury trial in this matter. Said words in which 12 people would be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After those 12 are selected, the evidence would be presented, they'd be instructed on the law. And then that jury would decide by unanimous verdict, meaning all 12 would have to agree, as to whether the state proved your guilt. Now, if you did not want to have a jury trial, but you did not want to plead guilty, you could waive in writing your right to have a jury trial, which means to give up. And in that case, then you would have what's called a court or bench trial, meaning the judge would be the one who would hear the evidence instead of a jury, apply the law, and decide whether or not the state proved your guilt. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a right to confront the witnesses against you and to cross-examine them through your attorney. What that means is that the witnesses against you have to come into court and testify in front of you and your attorney and anyone else is present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. The purpose of that is to try to bring out evidence that would help your side of the case. Do you understand that?
Yes, sir.
Under the Constitution, you have the right to use the power of this court to compel or force witnesses to come into court to testify excuse me, on your behalf, the same as the state. So if you have witnesses you're not certain are going to come in voluntarily, at your request, the court will issue a court order, that's called a subpoena, and that forces those people to come to court to be available to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are forced to come into court to testify against you. Do you understand that?
Yes, sir.
And now under the Constitution, you have a privilege against self-incrimination, which means that you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't. You make the decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person, and no one's even allowed to comment about it, except in one situation. If there's a jury trial and you don't testify, the judge instructs the jury that because that's your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Under the Constitution, you're presumed innocent of this charge. You'll prove it guilty by the state of Ohio on every essential element of the offense charged. So what that means is that the burden of proof isn't on you to try to prove you're not guilty. The burden is upon the state to prove that you are guilty. They must do that by proving every essential element of the offense by proof beyond a reasonable doubt, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
Right now, originally you entered a plea of not guilty. A not guilty plea denied the allegation in the indictment, denied you committed any crime, and exercised or revoked all the rights that I've just described for you. Now, if you change your plea from not guilty to guilty, that's the complete opposite of the not guilty plea. The guilty plea admits the allegations in the indictment, admits that they're a crime, that you committed that crime. And that plea waives, gives up all of the rights that I've just described for you, except your right to have an attorney. You always have a right to have an attorney, no matter what your plea. With that exception, your plea of guilty, waives, gives up your right to a jury or court trial. Waives, gives up your right to confront witnesses against you in open court and cross-examine them through your attorney. Waives, gives up your right to use the power of the court to compel or force witnesses come into court to testify on your behalf, the same as the state. The waiver gives up your presumption of innocence, because if you say you're guilty, then the state doesn't have to prove you're guilty. It also gives up your privilege against self-incrimination, because if you say you're guilty, that's what's used to find you guilty. Plea of guilty subjects you to being sentenced immediately by the court. And finally, it gives up any right to file an appeal you think you may have had up until this point in the proceeding. Now, if you are sentenced to the maximum sentence, or under other certain circumstances that are limited, you could file an appeal. That would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, sir.
And are you a U.S. citizen?
Yes, sir.
Now, do you have any questions about the intervention program or what's required of you?
No, sir.
You understand it?
Yes, sir.
Do you have any questions about the charge or the possible penalty?
No, sir.
You understand it?
Yes, sir.
Any questions about the plea agreement form that I've just gone over?
No, sir.
You understand it?
Yes, sir.
Any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
Yes, sir.
Do you have any questions first?
Oh, no, sir.
Do you understand?
Yes, sir.
And you understand all the rights I've explained to you here today?
Yes, sir.
Is there anything you need to speak with Mr. Wagner about before we go any further?
No, sir.
Then is it your decision to withdraw your not guilty plea, plead guilty according to the plea agreement, in which you would be put into the intervention in lieu of conviction program? Is that what you want to do?
Yes, sir.
All right, then as to the charge, which alleges that on or about May 21, 2023 in Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance with methamphetamine in violation of Section 2925.11 of the Ohio Revised Code, a fifth-degree felony, carrying a possible sentence between 6 to 12 months of incarceration, a fine of $2,500, and a possible license suspension of 6 months to 5 years. How do you plead?
Guilty.
Thank you. You can be seated. All right, the court finds on this date, open court, defendants advised of all their constitutional rights, made no intelligent voluntary waiver of the same. Pursuant to Criminal 11, the plea is accepted and ordered filed. Court finds that defendant's drug usage, alcohol usage, mental health, or other issues that are applicable was a factor leading to the criminal offense for which he has been charged and entered this plea. And intervention in lieu of conviction would not demean the seriousness of the offense. It would substantially reduce the likelihood of any future criminal activity. She has been accepted into an appropriate certified treatment program, TRC. She's otherwise eligible for community control. She's not a repeat or dangerous offender, and is otherwise eligible as set forth in the stipulated questions that were filed. So therefore, although the plea of guilty is accepted, the court will not make any findings this time, but rather will stay the proceedings to await report from the probation department regarding the defendant's progress in the program. She'll be placed on community control under the conditions for this program, under the supervision of the probation department for a period of 2 years. You'll be required to successfully complete your intervention plan, which is a TRC, and any aftercare, including the requirement that you must abstain from using drugs or alcohol for a period of 1 year. You're required to comply with all the conditions that I have adopted for this program. The probation department will give you a copy of those and go over them with you. And you'll be required to pay the cost of these proceedings. Now, if you successfully complete the plan and obey the conditions of community control and pay the court cost, then after that the court will dismiss the charge against you. You'll never have a felony conviction, and the case will be set to be sealed. And assuming nothing happens between that date and the sealing date hearing, then it will be sealed. Now, if you fail to comply with your treatment program, or if you fail to comply with the conditions of the supervision that have been that are ordered by the court under this program, then the probation department will file a notice of that with the court. There will be a hearing. You'll be represented by an attorney. If you don't have the money to hire one, the court will appoint one for you. And if the outcome of that hearing is that you have failed to comply, then at that time you'll be found guilty and be subject to being sentenced to a term of incarceration of 12 months, fined $2,500. If that happens, upon completion of that prison term, it is possible that the adult parole authority will place you under post-release control for a period of up to 5 years, 2 years, under the terms they set with the sanctions that I described for you earlier. All right, that completes the case. You'll need to report to the probation department immediately after court. You're no longer under pretrial supervision or the other conditions. You're now under the new conditions. So report down to the probation department, and they'll make the arrangements to do an interview with you and go over with those and have you sign all the paperwork. Anything further with council?
There.
Your Honor.
All right, thank you.
Thanks, sir.
Hey, Dan, this control box doesn't work. Do you know what did Ben mention something about it yesterday? Actually, your case isn't until 9. We got 8 minutes. You want to start early, Mr. Armentrout, or you want to wait?
We're ready now.
Okay. Well, just make a note of that. You're in a court that runs ahead of schedule, not behind. Yeah. So, are you questioning what I just said?
I was looking at the clock.
That was brave. Yeah. All right. Start the new year off right. Okay, this is case number 23 CR 162, State of Ohio versus Shannon Renee James.
Oh,
I'm sorry. I got the wrong file.
Okay.
Christopher Ray Pollard. Took it out of order. Present for the state is Assistant Prosecuting Attorney King. Present for the defendant is Attorney William Armentrout. And you are Christopher Ray Pollard?
Yes, sir.
All right, Mr. Pollard entered a plea of guilty to 2 charges of aggravated trafficking of methamphetamine, count 5, which is a 3rd-degree felony, and count 9, which is a 5th-degree felony. The court ordered a pre-sentence report, which I have received and reviewed. Have each of the attorneys received a summary?
State has, Your Honor.
Have, Your Honor, no additions or corrections.
All right. Anything from the state regarding sentencing?
Only was contained in the plea agreement, Your Honor, and the restitution to the task force in this case is $525.
To the task force?
Yes,
Okay.
that's
All
all.
right, Mr. Armentrout?
Stand up, Chris. I would ask the court to follow the recommendation of the state of Ohio and what we've agreed to, and that would be the court would place him on community control. Court's aware he's already in residential treatment, still has 3 weeks left there before he transitions to transitional control. He simply told me, like most people that suffer from addiction, Your Honor, that he feels better now than he's felt in years. And we'd ask the court to allow him to continue that, place him on community control.
All right, Mr. Pollard, is there anything you would like to say?
Your Honor, yes, that was the old me. I feel really good where I'm at. I just feel like a whole new me. I really do, Your Honor. This program has made me a better person.
Okay. All right, well, you can be seated. All right, well, Mr. Pollard, you're early in the program, and it's typical people feel a lot better early, but it's a long haul. It's not just a few weeks or a few months. It's a lifetime to get past this cycle of substance use abuse that you've had, and I'm glad that you're in the program on your own. So it is the order of the court that you be placed under community control under the supervision of the probation department for a period of 3 years under the following conditions. First of all, you're to obey all laws, all jurisdictions, conduct yourself in a law-abiding manner at all times. You must report when and as directed. You must be truthful in all statements you make to the probation department regarding your supervision. You'll be required to keep them informed of your residence and place of employment at all times. You may not change either without prior permission. You may not leave the state of Ohio at any time without prior written permission. You may not enter upon the grounds of any correctional facility, nor may you communicate with or attempt to communicate with anyone who's an inmate in any of those facilities without prior written permission from your supervising officer. Now, because of your conviction, you're not permitted under either federal or state law to purchase, possess, own, use, or have under your control any kind of firearm, ammunition, or dangerous ordnance. To do so would be a violation that subjects you to prosecution for a felony in both state and federal court. It's also a condition that you not have any of those items or any other weapons of any type while you're under community control in this case. You're not permitted to purchase, possess, use, or have in your control any kind of a controlled substance, drug of abuse, CBD oil, kratom, or any variant or analog of any controlled substance that has effects similar to controlled substances or drugs of abuse. Nor may you have any instrument, device, or thing that may be used to administer those or prepare them for administration, with the exception of any controlled substances or drugs of abuse or devices that are prescribed to you lawfully. If you do receive a prescription for any of those, you must provide a copy of it within 24 hours of receipt to your supervising officer, and you're to submit to drug testing when and as ordered. You may not purchase, possess, use, or have in your control any alcoholic beverage, nor may you be present in places where they're sold or being consumed, even if otherwise lawful. You're not to associate with anyone who is a co-defendant in this case, if there were any, don't think there were, nor may you associate with any other person who has a criminal record, is a member of a gang, or any other criminal group, or any person who has in the past, or could in the future influence you to commit a violation of these conditions or a criminal offense. And that applies to any family members other than those with whom you were living immediately before the commission of this offense. After the date of this order, you may not marry or establish cohabitation or common law marriage type relationship with another without written permission. You must report any contact with law enforcement or any arrest, citation, conviction, or other charge of violating the law not later than the next business day after that occurs. You must provide your supervising officer financial information records so your ability to pay restitution, fees, or costs can be reviewed. If you are referred by the probation department for an evaluation or assessment for any type of programming beyond that ordered by the court, treatment, therapy, educational program, etc., you'll submit to that, and if there's a recommendation for programming, you'll enroll in and successfully complete that. You'll be required to pay the court costs and make payment arrangements to do so. You'll be required to pay restitution through the victim witness escrow account in monthly payments as determined by the probation department. You'll be required to successfully complete your substance use disorder program treatment, which is abbreviated in the entry as SUD, at the counseling center and any recommended aftercare. Now, by being placed on community control, you're deemed to have consented to a search without a warrant of your person, your residence, vehicles owned by you or used by you, or any other property place that's under your control where you're found at any time by any officer of the probation department. And you'll be required to sign a written consent acknowledging that. There'll be no fine, there'll be no driving suspension. You're ordered to pay restitution, the amount of $525 to High County Task Force, payable through the victim restitution escrow account at the victim witness office, and you'll pay any service fees charged for that service. You're also to pay the court cost, and if you fail to do that or set up a payment plan and comply with that payment plan, then the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then the court could order you to do community service in this county and give you credit for each hour you worked, and an hourly rate set by the court. Each hour you worked will reduce your judgment by that amount until paid in full. Now, in the event that it's alleged that you have failed to comply with the supervision conditions imposed by the court in this order, then the probation department will file a written notice of that with the court and serve a copy on you. There will be a hearing at which you'll be entitled to be represented by counsel. If the outcome of that hearing is that you have failed to comply, then at that time the court can revoke your community control and then sentence you to a term of incarceration of between 9 and 48 months and a fine of up to $15,000. If that occurs, and you, as a result of being convicted of another felony, then the term of incarceration in this case can be ordered to be served consecutively to the term in the new case. Now, if you are sentenced to prison, once you complete that prison term, the adult parole authority may, at their option, place you under post-release control for a period of up to 2 years. They don't have to, but they can. If they do, you'll be supervised by a probation officer on the terms they set. Parole officer, I should say, on the terms they set. And if during that period they determine that you failed to comply, they can return you to prison and make you serve an additional period of up to 9 months for a single violation, but there is a cap or limit of half of whatever the prison term that was imposed by the court was. Yeah. However, if you're convicted of a new felony, then in addition, whenever sentence a judge in that new case can impose upon you, that judge is also authorized to sentence you for committing that new offense while under post-release control, in this case, to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. And if that occurs, that has to be served consecutively to the sentence in the new case. All right, is there anything further from counsel?
No, Your Honor.
No, Your Honor.
All right, well, that completes your case, Mr. Pollard. You're no longer under pretrial supervision, but you will need to report to the probation department for an appointment for intake so they can go over the conditions with you and explain everything to you and when you'll need to report and so forth. So you'll need to go down to the probation office then. All right, thank you.
Okay. Hey, good luck to you.
All right, Shannon James.
Thank you.
Case number 23 CR 162, State of Ohio versus Shannon Renee James. Present for the state is Assistant Prosecuting Attorney King. Present on behalf of the defendant is Attorney William Armentrout. And are you Shannon Renee James?
Yes, sir.
All right, Ms. James has entered a plea of guilty to aggravated possession of methamphetamine, a third-degree felony. The court referred the matter to the probation department and received a pre-sentence report. And I also referred the matter to the drug court. The report from the drug court coordinator was that Ms. James's ORAS is 13, which is below the level required for admittance into the program. So at this time, she does not qualify for admittance into that program. So with that, I'll ask the state if the state has anything they would like to say regarding, well, have each of you received a copy of the
State
summary?
Attorney. Yes.
All right. Either of you have, first of all, Mr. King, anything you'd like to say?
Only was contained in the plea agreement, Your Honor.
Okay.
Thank you.
Mr. Armentrout?
Be asking the court to follow the recommendation as it goes to placing her on community control. As I understand the low number is not necessarily a bad thing. The higher the number means the greater chance of relapse, I believe. So,
Yes. Yeah, it puts her in a low risk as opposed to a medium or high.
Okay. We'd ask the court to place her on community control. It's obvious from the nature of the case. And this was out of a traffic stop, Your Honor. It wasn't a trafficking or a sales situation. But she has struggled and continues to struggle. If the court would see fit to place her on community control, it's my understanding that there is a bed available today and would actually be leaving with the gentleman that transported Mr. Pollard today, and they're prepared to do that. So we'd ask the court to consider that, Your Honor, and place Shannon on community control.
All right. Ms. James, anything you'd like to say?
You don't have to, Shannon. It's up to you.
All right, then you can be seated. It's the order of the court that you be sentenced to a term of 3 years of community control under the supervision of the probation department under the following conditions. And again, I'll note that you're not eligible for the drug court at this time. You're required to obey all laws of all jurisdictions, conduct yourself in law, body, manner, all times. You must report when and as directed. You must be honest in all statements you make to the probation department regarding your supervision. You must keep them informed of your residence, place, and employment at all times. You may not change either without prior permission. You may not leave the state of Ohio at any time without prior written permission. You may not enter upon the grounds of any correctional facility, nor may communicate with or attempt to communicate with anyone who's an inmate in any of those facilities without prior written permission. You're disqualified under both federal and state law from possessing, purchasing, owning, using, or having under your control a firearm, ammunition, dangerous ordnance weapon of any type, and if you do so, it can subject you to penalty, prosecution under both jurisdictions. It's also a condition you not have any of those items while under community control in this case. You may not purchase, possess, use, or have under your control any controlled substance, drug abuse, CBD oil, kratom, or any variant or analog of any of those substances that have effects that are similar to a controlled substance or drug of abuse, nor may you have any instrument, device, or thing that may be used to administer or prepare those for administration unless you have a prescription for both the substance and the device. And you must provide a copy of that within 24 hours of receipt. You're to submit to drug testing when and as directed. You may not purchase, possess, use, or have under your control any type of alcoholic beverage, nor may you be present in any places where they're sold or being consumed, even if that may otherwise be lawful. You're not to associate with anyone who is a co-defendant in this case, if any, nor with any other person who has in the past or could in the future influence you to commit an offense or to violate these conditions, unless approved in writing by your supervising officer. It applies to any family members unless you were living with them immediately before the commission of the offense. After the date of this order, you're not permitted to marry or establish cohabitation of a common law marriage type of relationship with another without written permission. You must report any charge of any contact with law enforcement or any charge of violating the law or any arrest or conviction or citation not later than the next business day after that occurs. You must provide your supervising officer with financial information records so your ability to pay any fees or costs can be reviewed. If you're referred by the probation department for an evaluation or assessment for any type of treatment or programming beyond that ordered by the court, you'll submit to that. If the recommendation is that you undergo programming, then you'll enroll in and successfully complete that. You'll be required to pay the court cost and make payment arrangements to do that. You'll be required to successfully complete, and then she's going to the counseling center. All right. Successfully complete SUD treatment, which is substance use disorder treatment at the TCC, as counseling center, and any recommended aftercare. Now, by being placed on community control rather than being sentenced to prison, you're deemed to have consented to a search without a warrant of your person, residence, vehicles owned by you or used by you, or any other property place that's under your control where you're found at any time. Any officer of the probation department, you'll be required to sign a acknowledgement and consent for that. The court will not impose any fine or any suspension of driving privileges. You're also ordered to pay the court cost as a substantive order, and if you fail to do that, then the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then upon completion of, the court could order you to do community service in this county and give you credit for each hour you work in an hourly rate set by the court. Each hour you work will reduce your judgment by that amount until paid in full. Now, in the event the probation department feels that you have failed to comply with these conditions, they will file written notice that with the court, serve a copy on you. There will be a hearing, and you'll be entitled to have an attorney at that hearing. If the outcome of that hearing is that you have failed to comply, at that time the court could revoke your community control and sentence you to a term of imprisonment of between 9 and 36 months and a fine of $10,000. If you are sentenced to prison because you have been convicted of a new felony offense committed while you're under community control in this case, then the sentence of imprisonment in this case could be ordered to be served consecutively to the sentence in the new case. If you are sentenced to prison and serve a prison term, upon completion of that prison term, it is possible that the adult parole authority will exercise their option under the law to put you into what's called post-release control supervision. If they do, you'll be supervised on the terms they set by a parole officer, and if they determine that you have failed to comply, they can return you to prison to make you serve an additional period of up to 9 months for a single violation with a cap or limit of half of your prison term for all violations. However, if you commit a new felony while under post-release control supervision, then in addition, whatever sentence a judge in that new case could impose upon you, that judge would also be authorized to sentence you for committing that new offense while under post-release control in this case to an additional period of a year or whatever time is left on the period of post-release control in this case, whichever is greater. And if that occurs, that must be served consecutively to the sentence in the new case. All right, is there anything further from counsel?
No, Your Honor.
All right, that completes your case, Ms. James. You're to report to the probation department. I think they're going to have you conveyed right away to counseling center or recovery council for the new program. All right, so you go ahead and go see Mrs. Sturgill. Thank you.
Thank you, Your Honor.
You like Shannon?